Welcome to today's webinar on changes to the Families First Coronavirus Response Act. That's a mouthful. My name is Kathy Graham, and I think I know a lot of you that are attending today, a number of you. Today we're going to talk about some changes that are coming to the FFCRA, and also I'm going to go over the basics again because um, unfortunately a lot of employers out there have not been um, filing these claims like they should be, or filing these requests for leaves as they should be. And there are a lot of employers that don't know what's the basics of the law. So I'm rambling a little bit, but that's what we're going to go over, the basics along with the changes. So the Families First Coronavirus Response Act came out this early part of this year, actually a day after the Office of Pay Entry in Huntersville went virtual. We went virtual the 17th of March. This law is overseen by the Department of Labor, and so they have written, I think, about answers to about 123 questions about this on their website. You can look that up at dol.gov. Look for the FFCRA rules, and you can find that there, or text me, email me, and I will send that to you. Okay, the current laws contain several areas that impact employers, and there are two new paid leave programs that we've been dealing with all year. One is the emergency paid sick leave, the other is the emergency family and medical leave. And both of those result in tax credits if they're handled appropriately and if they're legitimate. We're going to talk about that today, how to do that. But the law has been modified recently. In fact, back in August of 2020, the U.S. District Court for Southern District of New York found that portions of the regulations were invalid. So the Department of Labor went back, reviewed their rules, and they have released a temporary rule with revisions and clarifications that were effective September the 16th of this year. So they're in place now. So let's talk a little bit about the two paid leave programs. Employers are required to provide. I'm going to restate that. Employers are required to provide. There are employers out there that don't know this, but you don't have a say-so. It is a law. And so you are to provide emergency paid sick leave and emergency family and medical leave if you have someone that qualifies. So on the emergency paid sick leave, there are 2 weeks of paid sick leave available immediately to all employees for reasons related to coronavirus. Full-time employees are entitled to 80 hours or 10 days, and part-time employees are allowed the number of hours that they typically would work in 10 days. So you would look back, you're allowed to look back 6 months when calculating those average hours. If you have a part-time person that always works 15 hours a week, there's no need to do that. You would just use the hours that they normally worked. The new rule from the Department of Labor clarifies who is eligible. First of all, the employee must be an active employee, and they cannot be furloughed or working reduced hours. If they are, they're not entitled to that benefit. The reasons that would qualify someone for this emergency sick leave are self-quarantine due to their own illness with the coronavirus. So that is self-quarantine because of their own illness. Obtaining personal diagnosis or care for exposure or symptoms. Assisting another individual who's self-quarantined because of COVID-19. And caring for a child under the age of 18 whose school or place of care has been closed or whose child care provider is not available due to COVID. I will stop and let you know that we will have question and answer period at the end if you want to type your questions in to the questions box as we go along. Brianna, who is in the HR services area, will help me with that at the end. And in addition, There is a handout today. On your screen, you should have it available as a copy of this presentation as a handout. So emergency paid sick leave employees are entitled to the full regular rate of pay for up to 2 weeks if the leave is for their own illness with COVID. All right, and I've underlined full regular rate of pay, and that is because regular rate of pay under the Department of Labor's rules includes any commissions or non-discretionary bonuses that they may have been entitled to in the pay period. So you do have to look back and see if you have someone that is commissioned or that gets regular non-discretionary bonuses. They might have to have a different rate than what you might call their rate of pay. But the regular rate of pay includes all items that are paid. We're going to have a webinar on that in the next couple of weeks because we want to make sure that everyone is aware of how to calculate the regular rate of pay. Okay, if you're caring for a family member who has the virus or for a child whose school or daycare is closed because of the virus, the required pay is only 2/3 of the regular rate of pay for up to 2 weeks. And see again, it is using the regular rate of pay. That's the Department of Labor's um, wording. So what if you already have a sick leave program at work? Well, this leave is in addition to anything you already have. You can't change your existing policies to avoid paid sick leave obligations. So um, taking your sick leave plan away because this exists is not an option. You also can't require that employees use other paid time off, like their personal days or vacation or anything in a PTO bank before they use this new emergency paid leave. There's a notice that you have to post on the Department of Labor's website. It's accessible there, or I can send it to you. You have to post a public notice that informs employees of their rights to emergency paid sick leave. And they have a model notice, as I mentioned, at the Department of Labor on their website. If you just Google Department of Labor model notice for COVID, it'll pop right up. But you have to post that in your workplace. And here on your presentation that I have sent you as a handout today, you'll see the website where you can reach that poster. Okay, so let's now talk about the Emergency Family and Medical Leave Act. That was sick leave. This is the family and medical leave. Emergency family leave is available when an employee is not capable of working or they can't work because the child's school, daycare, or someone that's taking care of them is not operating due to the pandemic. It is only available then. So remember, sick leave is only 10 days. This is a whole different reason for a leave. It means that they have to take care of their children that are not in school. I heard today that New York City has closed all of their schools because of the COVID again. And so that's going to put a lot of parents in a place where they have to decide whether they can go to work or they need to stay home. It's a tremendous burden on working parents today. Also, this is basically a temporary extension or expansion of the FMLA law. What it does is it adds 12 weeks of job protected paid leave in this public health emergency. So the two key things here, remember under FMLA, the leave is not paid. And this leave, the leave is paid and their job is protected as it is under FMLA. So you have to hold their jobs. The first 10 days can be unpaid, but remember they can use benefits offered under the emergency paid sick leave program that we just talked about, and other forms of accrued paid leave like vacation, personal leave, that kind of thing. After the first 2 weeks, employers have to pay workers at least 2/3 of that regular rate of pay. And to be eligible, the employee must have worked for the employer for at least 30 days. Now, this applies to part-time and full-time, just like the sick leave benefit. The leave can be intermittent or on demand, and this is one of the new rules. They have stressed in the new rule that employers need to be flexible and work with employees to make sure that every employee is taken care of and can take care of their children when they need to, because sometimes it may not be something where they can give notice. You have to do it on demand now. The definition of child under this law is different than other laws. It includes a biological, adopted, or foster child, stepchild, legal ward, or a child of a person that's standing in loco parentis. That age limit is 18, and those who are 18 years of age or older who are incapable of self-care because of a mental or physical disability. However, an employee requesting leave to care for a child that's over the age of 14 needs to certify special circumstances exist that require them to um, take care of that child for the employer to actually claim the tax credit. So that we're going to talk about documentation in a minute, and that'll be important for you if you have someone who's doing this for a child that's over 14. They have to have special circumstances in order for that um, child care to be tax available to the tax credit. So under the law, healthcare workers and emergency responders can be exempted, but with the new um, DOL compliance statement, the term healthcare provider has a much narrower definition than it once did, or the original definition. So it means that any employee who meets the definition of a healthcare provider under FMLA, and there is a definition there, and those employed to provide diagnostic, preventive treatment, or other services integrated with the necessary to provide patient care. And if they didn't do that or didn't provide that care, it would adversely affect patients. So there's still some gray area there, but it may narrow it down some for those like dentist offices and some of the people in the healthcare industry that don't actually provide patient treatment or care. Because for those in the healthcare industry, it's been a little bit confusing. The Department of Labor can exempt small businesses, that is those with fewer than 50 employees, if the business would be in financial jeopardy. But don't send your request to the DOL in writing. They don't want it. What they want you to do is put a process in place that documents your financial status, and one of your top your owner or one of your top management has to certify or state that the business would be financially impacted in such a negative way that it could affect its your longstanding, or your existence. So it can be done. If you need steps on that, let me know, and I can send you the steps involved in putting that statement in place. Employers with fewer than 25 employees don't have to comply with the job protection aspect of this bill. So only those that have more than 25 employees. Record keeping requirements. This just came out with the new DOL statement. Record keeping requirements include the employee's notification, and that can be a verbal notification, but if it is, you have to write it down and put it in the files. You need documentation to substantiate the leave. The documentation needs to include the employer's name, the date of requested leave, why they need the leave, and a written statement that the employee is unable to work or work at home. So that written statement obviously would come from them. And as I mentioned, oral statements are allowed, but you need to do the documentation if they don't provide it for you. That documentation under the DOL laws need to be kept in your files for 4 years. I would say at least 4 years. As in human resources, we don't throw much away because if we do, it comes back to bite us. So we hang on to things a lot longer probably than we need to, but it does pay off in some situations. So when you give your employees this leave, you have a tax credit that's available to you. There is a refundable payroll tax credit for employers that provide this emergency sick leave or FMLA leave through 2020. So it does expire 12/31/2020. But I've talked to so many employers in the last 2 weeks that have claims now that didn't have claims earlier in the year because of the widespread nature of the virus. And so I think that we're going to see a lot of people using this before year end. Okay, for paid emergency sick leave, if employees take a leave to quarantine, um, or for their diagnosis or treatment, or treatment of coronavirus. Let's just say they need to go get a test, or they need to go to the doctor for that. It is covered under this leave. So if they come into contact with someone and they need to self-quarantine because of that contact, that would be covered under this. So there are many instances where people don't have the virus, but they've come into contact with someone, then that means that they can't come to work. They need to be quarantined. The tax credit is of 100% of the wages that you pay to them, up to $511 a day, and there is a maximum of $5,110, which is the 10 days that they would be allowed. But dollar for dollar, you're going to get your money offset in an immediate tax credit once you pay them. So this is really not an out-of-pocket expense for the employer. For employees that take leave to care for a family member, or if the daycare is closed or there's a school closing, then the tax credit is $100. I'm sorry, I meant to change that. 100% of wages up to $200 a day with a maximum of $2,000. So there's a different level of benefits, and I apologize that for it shouldn't be $100. It should be 100% of wages, up to $200 a day with a maximum of 2,000, which would be the 10 days. First one is for the person's personal diagnosis or quarantine. The second one is to care for a family member that has COVID, or to take care of a child who's out of school because of the COVID virus. Okay, so let's look at more about the tax credits. For paid emergency FMLA leave, the tax credit is 100% of wages up to $200 a day. Now, this is where you're paying them 2/3 of their wages. So your tax credit is worth $200 a day. There's a maximum of $10,000 per employee, because remember, this leave lasts another 10 weeks. In our system at Pay Entry, we've created codes that you can use to put in the hours for, let's just say someone is out because they're quarantining. You would use the CRA sick code, and that would automatically trigger a tax credit in your file so that you don't have to do anything with it. Also, CRA care is for when someone is taking leave to take care of a dependent, or their child has a daycare or school that's shut down. And then CRA child leave is under the employer, or actually the emergency family medical leave. That's when they're out to take care of a child that cannot be in school or daycare because of COVID. And not for sickness, but because the school or the daycare is closed. But these are the 3 codes that you use in our system. And if you have any questions about those, please reach out to your client advocate. They'll be happy to help you with that, or you can contact me or HR services. We'll be happy to answer those questions for you. But you do need to use these codes in order to get your immediate tax credits. We'll do the work for you, but you need to put the code and the hours in there so that we can take care of it for you. So FFCRA leaves expire 12/31/2020, and there has been an extension proposed in the HEROES Act that passed in the House back in May of 2020. The Senate has not taken up the legislation, but the bill, if passed, would extend leave provisions through the end of 2021. So I believe probably after the probably at the end of January, we will hear something about this. So what should you as an employer be doing right now? Well, number one, make sure that you are familiar with the current laws and that your company is complying with that, because there are fines and penalties that are being assessed. Employees that complain that they were not paid for the time off can get back pay, and then the employer has resulting penalties. So you need to pay attention to whether or not you're doing it and doing it right. Check your documentation, make sure that you could go back and prove to the Department of Labor or the IRS that you were eligible to take that tax credit, and take advantage of those tax credits. It's dollar for dollar up to certain amounts, and in some cases you won't have any out-of-pocket expenses. Remain aware of any extension. We will keep you posted on that, and hopefully we'll know something by the end of January on that. Okay, are there any questions?
We got lots of questions for you, Kathy, and they're really good ones.
Okay.
All right,
right,
let's start
okay.
with this one.
Fire.
All right, if my child has a fever or is exposed to COVID and the employee must take off to stay with the child, would this be covered, or could I have the employee work from home?
If the employee can work from home, yes, you can require that if it is possible for them to work at home. But they are also, if they can't work at home, or they don't think that they'll be able to take care of the child and work at home, then they have the availability of this leave, but it would cover this because they would be covered under the part where the child is being taken care of by the employee, and that would be under the employee, I'm sorry, the paid sick leave part of it.
Okay. All right, next question. Emergency family and medical leave, does it follow the same number of employee guidelines as regular FMLA, or is it a certain number of employees? How is it? How do we determine who's covered?
Okay, it doesn't use the same requirements as FMLA. You know, FMLA requires 50 people, 50 employees in a 75-mile radius. This does not do that. It's all employers have to comply with this, down to one employee.
All right, and same question for emergency paid sick leave. Does that have a minimum number, or is that everybody too?
It is every employer.
Okay.
Now remember, on the Family and Medical Leave Act, if an employer that has less than 25 employees can document that they would be in dire straits if they allowed this and paid it, then they can get an exemption from the Department of Labor. But that probably would be pretty rare. You'd have to be, going under for them to allow that. So it does cover everyone.
Okay. All right, next question. If my company has to shut down due to an entire department getting COVID, do I have to pay the employees for the 10 days? If so, how do I pay people with no revenue coming in?
Okay, if you're shutting down your company because a department had COVID, I probably would need more specifics about how big your company is, because you shouldn't shut your entire company down because you had a department with COVID. There are ways to have people work and continue to work, but let's just say you do have to shut your company down. If you're furloughing people, they're not eligible. It's only if they would be working that this benefit would be available. So the new law says that they have to be active employees. So if you shut down, you're either terminating or furloughing people, and they would not be eligible for this benefit. They have to be eligible, or I'm sorry, they have to be working.
Okay. If an employee has used the 2 weeks of emergency paid sick leave and then they have to quarantine due to doctor's orders from exposure, can they then get emergency family and medical leave?
They cannot. That is only the paid sick leave is available for self-quarantine. So they're kind of out of luck for pay unless you have a sick leave program or a PTO program where they can draw from their PTO and sick leave.
Do we get 100% tax credit on what we paid to the employee?
Yes, you do. You get 100% of the tax credit up to the limit that's set for each of those categories. So for the first one, it's $511 a day and $5,110 for the 10 days. So you would get a total 100% credit for anything you pay up to the maximums established.
Gotcha. All right, where you say on the sick leave for eligibility, what do you mean by they cannot be working reduced hours? Is that during leave that they cannot be working remotely for some of the time?
It is, well, if you've reduced them to part-time status, that doesn't mean, I think there are some questions about that one. I knew someone who was going to ask that question because to me, you would still be able to pay them for the hours that they were working, but they have to be able to work. Brianna, why don't you get that person's information and let me get back to you because I had a question about that myself and want to do a little bit more research on it.
Okay, I will write that one down. All right, what is the tax credit for employees who, who have to quarantine because their spouse has COVID? Does that go into the caring for a family member category?
Well, it could be a self-quarantine because of exposure to someone with COVID, because that obviously, if you're the spouse, you have been exposed to your significant other. So you would be quarantining because you've been exposed at that point in time. It would be the
Okay,
first type of leave.
okay. If a company paid holiday falls during during the FFCRA period, the employee is still getting paid. How is it coded when processing payroll? Do we code that as holiday pay or CFRA sick pay?
If you would pay someone who is out on a regular leave of absence, then you would go ahead and code it as a holiday pay instead of FFCRA. It depends on some people. You have to, in some companies, you have to work the day before and the day after. And if you're out on a leave, you don't get paid for the holiday. You have to use your own. So it just depends on how your company handles it. But it actually would, you could quote it holiday pay or you can do the FFCRA. I would say I would use the holiday pay code.
Okay. If the quarantine is not government ordered, but due to close contact with a COVID individual, does that still qualify for the emergency paid sick leave pay?
Yes, it does.
Okay.
By government ordered, I think they're talking about, remember when this first started, counties were shutting down, states were mandating that people stay at home on lockdown. So that's when it's government ordered from a state or a local perspective. If let's just say one of the counties in your state says everyone needs to hunker down, nobody can go to work, then that would qualify because it's government ordered. But
Okay.
otherwise, it would cover anyway if you have been exposed.
Gotcha. Okay. All right. For the tax credits, if we have to pay an employee 2/3 of their normal rate of pay per day and it's more than $200, then we are not getting the full tax credit. So are we losing money for any employee that is paid more than the $37.50 an hour for the family leave scenario?
You're not required to pay them any more than the benefit offers while they're out. You don't have to pay them their full pay. If your tax credit is going to cap out at $511 a day and you have someone who makes more than that, you can cap the pay at $511 if you want to do that. That's totally up to the employer.
What if the employee is staying home waiting for a test result?
If they have been exposed to someone with COVID or they have symptoms, then that is paid sick leave. That's the emergency paid sick leave benefit. They are entitled to do that.
Unless legislation is passed, all of this will be over December 31st of 2020, correct?
Correct. Mm-hmm.
Okay.
I hear
If we
cheers out there.
right? You should hear them in your head. Everyone
Right,
goes,
I hear them in my head.
yay!
Yay.
If we won't know if it's extended until the end of January, should we go ahead and pay or not pay during January?
That is totally up to you and your organization. You may or may not get a resulting tax credit. It would be nice if we would know this by the end of the year, but we won't because nothing gets passed, will get passed until the end of January, I don't think. And that's speculation. It could happen. But each company, I was going to say, each company is going to have to decide how to handle going into January because COVID's not gone and people are still going to need to be out on leave. So if you want to continue paying the benefit in the same manner, anticipating that this will come to pass, then that's one thing, but you're not required to. After January 1, you can have a person use their sick leave or vacation.
Okay. All right, so the employee gets paid in full if they are home with their child who is quarantined under the paid sick leave up to the 80 hours, and then it would switch over to FMLA after that and the 2/3 pay. I think they mean the EFMLA.
If I'm not mistaken, you pay them 2/3 of, if they're out under the paid sick leave portion, it is 2/3 of pay. Unless it's for their own illness or quarantine, it is 2/3 of pay. So they would not be getting their full pay.
So if the child is under quarantine, is that still the 2/3 or would that be
Uh-huh.
the full 80
Yeah,
hours?
it's
Okay,
the 2/3.
okay,
It's 2/3 of pay for 80 hours.
gotcha. All right, if I am already working from home and I get COVID and I can't work, am I covered under FFCRA?
Yes, you are. If you can't work at home because you're sick, then you're, or you have been exposed to someone. Now, if you've been exposed to someone, your employer might argue that you can still work. But if you have COVID and you're sick, you are entitled to the emergency paid sick leave benefit.
Previously, if you had more than 500 employees, you were not required to pay this. This is still stated on the Department of Labor Q&A website currently. Was this one of the recent changes? And do you have links to updated DOL guidelines if it's changed?
Okay, you're right, and I should have mentioned that up front. I need to put that in this presentation. It is employers that have fewer than 500 employees. Only. They're picking on the small guys. There are states and different areas, parts of the country that have adopted laws for those companies who have more than 500, but this specific law deals with employers that are under 500 employees. And thank you for bringing that up. That's a good point. We don't have very many. I don't think we have a lot of companies that have over 500 employees that they pay on a regular basis. So I guess I'm more focused on the small people, small companies.
Gotcha. Do you use the limit for hours or the limit for dollars first?
You have to use both because you're not going to pay them more than 80 hours. And you could pay them over $511 a day if they've earned that, and they'll run out of benefit before the 10 days, but you can't, it's both. You have to apply both to the scenario.
Does an employee have to use vacation or other PTO before applying this leave?
Absolutely not. You're not required them you're not allowed to require them to use their sick or vacation. This benefit comes first.
Okay. Can someone get paid the paid sick leave twice? For example, if they were off in May due to having to quarantine and then again in September if they had to quarantine due to exposure again?
No, it's a one-time 80-hour benefit. and they can only use it once.
If I didn't code the hours correctly in the payroll system, can I fix it?
Call your customer service person, your client advocate, and they will help you fix that. Yes, you can.
If we've already paid certain employees for their sick leave, but we did not code it as CRA, how would we go about getting the tax credit?
That would be the same thing. Talk to your customer service rep, your client advocate, and they will help you fix that in the system.
Okay. If we send an employee home to get a COVID test, and tell them not to come back until they have a negative test, do they fall under the 80 hours of paid time off?
Yes, they do.
Okay.
And the CDC is not recommending, and most of the health departments don't recommend that you require a negative test to return to work. If the person goes out and didn't test positive, they can come back to work if they have no symptoms. So getting a negative test before they come back is a little punitive. There's such an overload right now in the physician's offices and the clinics for testing. If they don't have any symptoms and they tested negative the first time, then let them come back. If they tested positive, they need to come back after they're symptom-free for 3 days.
If someone has to stay home because a young child's school is closed and they can't work their normal 8 hours remotely, but they can work a couple of hours a day, then would their pay for that time be the 2/3 pay because the 2 hours didn't equal 2/3 of that day? Or do we pay them the 2/3 pay plus the 2 hours that they worked?
You pay them the 2/3 pay plus the 2 hours that they worked. I feel like I'm on a quiz show here.
You're doing great. All right, we got a couple more. If an
Okay.
employee is sick and are required to have COVID testing before being allowed back to work, who is responsible for the cost of the test, and should the employee be paid?
If you as the employer are requiring it, then you should pay it.
If an employee travels out of the country, can I use the COVID tax rate while the employee is quarantining and waiting for test results before returning to work?
Say that one again.
If an employee travels out of the country, can I use the
Mhm.
COVID tax rate? I think they're talking about the payroll codes while the
Mhm. Okay.
employee is
All right.
quarantining before they can
Yep.
come back to work.
Yes, you can. Mhm.
I had read that paid sick leave eligibility depended on a healthcare provider directing or advising the person to get tested or stay home, that the employee is not allowed to self-diagnose. Can we require that medical element to use the paid sick leave?
Yes, you can. You can say that they need to go, number one, if they have symptoms, they need to go to the doctor and they need to bring something for documentation so that you can just determine that they do need to be out on a leave. If they have symptoms, go to the doctor or they've had a positive test. So the answer to that question would be yes, you can require documentation.
All right. And then this is our last question. If we use the FFCRA during January of 2021 and it is passed, will we then get back the tax credit?
It's speculation on my part, but I would say yes, because if it goes into effect, it would go retroactive um, to close the gap. So I would say that if I were doing it, I probably would go ahead and do it because I feel fairly strongly, but I am not a politician, an attorney, or anyone that has any ends with the Senate. So it's just a matter of waiting to find out. Some employers, I believe, will continue to do this and anticipating that they will get a tax credit for it. And in fact, if they don't, it would be a goodwill effort.
Sorry, we had two other questions pop up. As a follow-up
Okay.
to that, will pay entry shut off those CRA codes during January if we don't get notice that it did get extended?
I will have to talk to the powers that be about that. We have not discussed it yet, but it's on the horizon. I would assume that we would leave them there because you're the one that selects them. And once a code is entered, we don't normally take away a code. We would leave them there if you wanted to use it for something else in the future, or if we needed to use it in January. So my answer is I don't think they're going to take the codes away. You just wouldn't use them if you don't want to get a tax credit. We will shut down the tax credit piece of it though, so that it's not automatic, but you could still track the hours if you wanted to. So I know that the automatic tax feature will go away on 12/31.
Okay. 2 other questions. If an employee is off with their child, we only pay the 2/3 pay, correct?
That's
If it's care
correct.
for a family member, okay.
That's correct.
And if the employee is off sick and we pay the 80 hours of FFCRA and then they are home with their children, do they then get the 2/3 pay after the 80 hours has been paid out?
It would move over to the family leave benefit.
Mhm.
And yes, then they would get the 2/3 pay for any time that their child's school or daycare is closed.
Perfect. Well, that's it,
Now,
ma'am. Those are your questions.
I've thought of something else too.
Sure.
If, for example, the parent has an option to do school at home, like virtual school, or they can send their child to school, if they opt for virtual, they would not get the benefit. That's one thing I wanted to point out, um, because they're making a decision to not go to school.
Okay.
And that just popped into my head.
So
Okay.
it only
All right.
qualifies if there's no option for any type of
Correct.
child to actually attend a physical school.
Virtual.
Okay.
Yeah. If they can attend a physical school and you choose the virtual side, then that you would not get the benefit.
Well, that's it. Those are all your questions, ma'am. You did a great job.
Okay. Thank you very much, Brianna. And everyone, I wanted to go to the next slide and just remind you of something coming up. Brianna's going to be teaching a 2021 state legal update mini-series, and you're going to want to sit in on one of these, figure out which states that you have employees in, and sign up for that webinar. It's going to give you an update on everything that happens in or that's changing in 2021 for that particular state. And Brianna, anything else you want to add on that?
Just a quick edit to this slide. Utah actually doesn't have any updates. There was going to be an update, but it's no longer an update. So Utah is the only state that is no longer on this list. All the other states
Okay.
are still there, and there are going to be a lot of laws that are coming up starting 2021. So find the states where you guys do business, where you have employees, and join us for those webinars. Bring lots of really good questions.
And you can sign up on our website, payentry.com/webinars. Pretty straightforward. We appreciate your time today. If you have any questions or need further information, please feel free to contact me. My contact information is on the handout that you can pull from your dashboard today. So thanks for attending. And Brianna, what's the next webinar up on our list? You
I
have one
believe
next
next
week,
week
don't
is
you?
oh no, next week is Thanksgiving. So we are going to kick off
Oh,
our
that's
very
right.
first state law update for California. Lots of information of California. If you guys either do business there or you have at least one employee in California, I highly suggest that you come to our webinar on the first Tuesday of the month, which is December 1st. It's going to be chock full of information. So I highly, highly recommend it if you do business or you have an employee in California, because there's lots changing and it's good things to know because they will affect you as an employer.
Okay, well, thank you for attending today and have a great rest of the afternoon.